And we'll call next Robert McCluskey. Good morning, Mr. McCluskey. Sir, there's one charge for you. It's a charge of trespassing. This allegedly occurred at 1001 Arapahoe on September 3rd of 2024. This case may also be eligible for the community court process, Mr.
Arapahoe. It was at the park downtown. I was feeding the homeless people.
Well, it alleges that it was at 1001 Arapahoe. That's what it alleges. So let me tell you a little about of course, I don't play any role in deciding what the ticket says from the officer, but the officer has indicated that that's where they believe this occurred.
I'll take it to the Supreme Court. I'll take it to trial. I don't want to be here anymore anyway.
Well, you got to stick around so I can finish your case. I don't want to have to issue a warrant, so you better stick around.
Oh, it's going to be a good day for the fucking constitutional judge. Let's get
Mr. McCluskey,
it.
please watch your language in my court.
Let's get it done.
All right. I need to finish discussing the case with you. Won't take very long, but if you want to make it last a long time, it could. I don't want it to be like that. Let's just simply get through it. You have the option today of pleading guilty to the charge or pleading not guilty. If you'd like to speak with one of the navigators about your circumstances, or if you'd like to speak with one of the prosecutors, you have the option of doing that. What would you like to do?
Plead.
Do you want to plead not guilty to the charge?
I don't plead nothing until I talk to my constitutional lawyer.
So would you like to apply for the public defender?
No.
Do you have a lawyer that you anticipate contacting? So it sounds to me like you'd like to reschedule so you can have the lawyer interact with the lawyer and then come back to court?
Sure, let's do that.
Okay. We'll reset your case. And we'll reset it 2 to 3 weeks out.
Okay, thank you.
Hang on just a moment so we can get you the date. I'm going to send you right to, when you exit the courtroom, just turn to your right. The clerk's going to give you a court date. And then when you come back, we'll address your case at that time. Make sure you get that setting notice from them. If they don't get a setting notice, then you haven't finished your court appearance, and I really don't want to issue a warrant.
The evidence against me brought up in court that day too.
At that time, it'll just be an advisement of the charges, and the police report will indicate what the allegation is. That's the only evidence that will be in front of me at that time. It won't be a trial that day. That will be just a day for you to appear and either plead not guilty or guilty to the charge.
Well, regardless.
Would you prefer to plead not guilty and set for trial today?
I'm not pleading to nothing because it's stupid to even be here. It's a public park for the public. It's not a state. You guys in the state don't have any jurisdiction over that park. It's for the people.
You keep saying you guys. I don't have any role in what the prosecution of the police department does. My job is to decide whether, in fact, you're guilty of the charge. I'm sorry?
Can I go get my next court date now?
Yes. Exit to the right. Make sure you get your setting notice.
That they are committing treason. This is treason. They're violating my rights.
Let me go ahead. Looks like
All right, this is all Alyssa's fault. This stuff, it must be. We're doing this the greatest case in history over on Vlog Talk with Mike, with Mr. Lau. She might have been kicking around in these Colorado calls. These aren't new, but I haven't seen them. They're fun. Here's another one from Colorado. That last one was Judge Kahn, who's on that case. This is a judge I haven't seen before.
I have some.
Afterwards, he came in just a little bit later, so this is just, but this is not CUR judge.
You're right.
Yeah.
Can I ask a question?
Are you the one who want to talk to the city attorney? No?
Yeah, I've already been assigned an attorney through the Alternative Defense Counsel.
You've hired counsel?
What's that?
Did you say that you've hired counsel?
Yeah.
Okay.
I was assigned.
You want to apply for counsel?
No, I have counsel. I have an attorney. Reiner, I have an attorney.
Hold on one second. Let me, are you,
Mr. McCann.
you Mr. McCann?
Yeah, I'm not sure.
Who's your lawyer?
Brian Coulson?
Okay. Have you hired him?
Oh wait, is this the same guy, Mr. McCann? I think it is. I think it's the same guy. 2 appearances.
Yeah, he was assigned to me through the Alternative Defense Counsel.
Don't worry, it gets worse.
Come on up to the stand. So you want me to set this over so that you can get him here?
Yeah, I'm wondering, I would like my case to be dismissed because it's unconstitutional. I was assaulted. I was nearly hit by a car. I ran after it down the road, and stood in front of it while I was on the phone with 911.
Well, you brought up a number of things, okay, so I'll take them one at a time. The first is that you have the right to talk to the city attorney if you want. You can explain to them why you think the case might be dismissed. You're not obligated to talk to them. If you've hired a lawyer, I'm going to set your case over so that your lawyer can be present to protect your interests.
Right. So my lawyer is between the gross negligence and unethical conduct. I've already turned him. He's not responding to my. He's not communicating with me. So I've turned him into. I reported him to the Supreme Court.
It's cute when puppies do it.
And yeah, I don't understand why my case hasn't been. I don't understand why my case is not being dismissed.
Okay. Now, did you wish to be heard?
Yeah, Your Honor, I think Mr. McCann's attorney might have been assigned to him through a different
Does Barry Manilow know that you raid his closet?
court. I
Oh,
think
gotcha.
it might be best if he wants an attorney in this court for him to apply for the public defender service.
Right. So
Do you have cases in county court?
yeah, that's why I was assigned. Right. I was assigned a new attorney through the Alternative Defense Counsel because there was a conflict of interest through
With the public defender.
office. They switched me over to public defenders, several public defenders multiple times without telling me.
Do you want to apply for a court-appointed lawyer?
No, I would
This case?
I don't understand why my case is not being dismissed. I was nearly hit by a car. That's attempted murder, and here I am having to fight a charge for obstructing traffic.
Yeah, I don't
I was
understand.
also assaulted by a police officer.
I don't
know that I was obstructing traffic.
I don't know anything about your case.
All they did is went up to pedestrians.
And so if you have a motion to dismiss the charges, you're welcome to file that, and then we can present evidence about whether the case should be dismissed. But I don't know anything about your case.
Also, why is this lady here allowed to verbalize killed Chris McCann, killed Christopher McCann? You also verbalized murder Chris McCann. I don't think there's anyone else in this room with my name.
Yeah, I never
Also,
said.
the judge magistrate.
Hold on a
I'm a
second.
little aware the judge magistrate and Jeff.
Okay. Well, to answer your question, the First Amendment, and we doubt it happened.
Jefferson County.
Hold on one second.
I'm being forced. I have a disability. I had to walk here this morning. I'm being forced to live on the street so I can stick around for these ridiculous charges.
Yeah. Go have a seat for one moment, please. Thank you. I mean, right here. You're welcome to sit here. You're welcome to sit here.
This is fine.
Okay. So look, a couple things. First of all, I haven't heard anybody say anything about killing or murdering
It's on camera.
anybody,
It doesn't matter.
anybody in
The
this.
judge magistrate did when I was at it here. I'm a little scared for my leg because the judge magistrate said she told me that someone was going to be murdered with a shotgun.
Yeah. I don't know who you're listening
Yeah, I
to.
wasn't allowed in the court. So I also wasn't allowed into the courthouse last week or 2 weeks ago at the Jefferson County Courthouse because I had cans in my pack.
Yeah, I don't know anything about that either. So hold on one second.
The thing is, I'm a little scared. I'm a little worried. The lack of security. I'm being forced to live on the street. I can't stay at the shelter in town because someone has a protection order.
All right. So, Mr. McCann, I'm going to appoint a lawyer for you in this case. I'm going to find you eligible for court-appointed counsel, and then we're going to set your case over so that you have the opportunity to talk to your lawyer and decide whether or not the lawyer thinks it's appropriate to file a motion to dismiss or whatever.
I can't help but question your sanity if you don't actually think those things were verbalized 10 minutes ago.
Well, I'm sure you're not the only one who's questioned my sanity in the past.
I don't really think I need to give you.
Let's get you a court date.
So why aren't the police?
I do like the judge. He's mellow. He's talking to someone who's clearly not there, who questions his sanity, and then he pretends to roll with it. I liked it.
Responding to calls and ordered. Why is the judge magistrate?
Mr. McCann, You're not the only person that has court this morning. I've appointed a lawyer for you. I'm going to give you a court date, and then I need to deal with these other cases.
I don't have my rights.
So go ahead.
I don't have my rights. This
I'm not going to argue with you.
It's unconstitutional.
I'm not going to argue with you. Go outside and get
I
in.
am. I'm fighting for my life here. Do you understand that? Do you understand the police are driving through town saying I'm gonna be murdered, I'm gonna be sprayed? It's on camera. I'm gonna be sprayed. What does that mean?
I don't know.
What does that mean?
Go outside and get a new court date, and we'll have a lawyer here for your next date. Okay? Go ahead and step outside.
Why am I being charged? Why am I?
I'm done with your case. Step outside and get yourself
You're
a
done.
new court
How do you
date.
explain the injustice? How do you explain what's happening?
Stop.
How do you
Enough.
explain what you just verbalized? You just
Enough.
verbalized kill Chris McCann, murder Chris McCann.
Have a seat outside, okay? And we'll give you a new court date.
Why was I able to walk through this courthouse last week and scream, someone is going to be murdered with a shotgun at the top of my lungs? No one did anything. Not an officer, not an employee. No one said a word. How is that possible?
Calm down,
Why was
please.
I allowed to walk through this courthouse screaming those things?
Mr. McCann, calm down, please.
Because we need a mental health facility and mental health experts to help people. So
Calm down, please. Okay?
Why wasn't I arrested? So why wasn't
I don't
why
know.
wasn't I arrested?
Mr. McCann,
That's not legal. You can't walk through a courthouse and scream. You can't shout those things.
go
Come on.
ahead, go ahead and step out.
How does that make sense? I have to tell. No, you need to. When there's all right. Oh man.
Thank you, officer. I think,
Everything good, Your Honor?
yeah, we're going to give him a new court date outside, and I've appointed a lawyer for him. I appreciate you being here. I think he's just worked up. But thank you.
Anything else you need from us, sir?
I don't believe so. Thank you.
Very good. You're welcome.
Thank you.
How we doing?
So I apologize to you folks. Court proceedings can go sideways sometimes, and you have the right to expect that you can come to court and not be afraid. And if anyone was frightened by that, I apologize for that. Let's start again.
Good morning. This is the 13th Judicial District, Butler.
All right, this one here is Zach's fault. Shout out to Law Nerds Unite. Just killing it over there.
County Court, 13th Judicial District, District Court of Butler County, Kansas, this 21st day of April, 2025. This matter comes
Oh, yes, we've got a Darren Patterson client, people. You know it's going to be good.
on for our misdemeanor control docket. I see we do have someone at the detention facility. What is your name, please, if you'd unmute?
Amanda Harmon. Miss
Harmon,
Webster.
have you spoken with your attorney this morning?
Judge, we're ready to proceed.
Very well.
You should have received a report on her, Judge, as well as a proposed order.
I did see the report. Let me check the proposed order.
I think the email came out last night.
And I saw that it popped up on my screen this morning. Ms. Harmon is charged with driving while habitual violator. We did have a competency evaluation that was completed. Give me just a moment, please, to pull that back up. And if I didn't say so, we'll now be on the record in case number 2022 TR 3025, State of Kansas versus Amanda Rose Harmon. Please announce appearances.
Jared Regier on behalf of the state.
Darren Patterson, court-appointed counsel for Amanda Harmon. Ms. Harmon does appear from the Butler County Jail.
Thank you. And pursuant to a competency motion, I have been supplied from Mr. Patterson, a South Central Mental Health Counseling Center competency evaluation report. The date of the order, November 25th to 24, date of referral, March 20th to 25, and the dates of evaluation, March 24th, 2025, and April 2nd, 2025. And examiner, Dr. Chelsea J. Nguyen, LP. She does report that on March 20th, 2025, the history as I've stated. As far as summary of competency, based upon the definition of competency as outlined in KSA 38-2438B2, the examiner would recommend finding Ms. Harmon incompetent to stand trial. This finding that Ms. Harmon does seem to somewhat understand the nature, that is prong one of the charges against her, but her current presentation rendered her largely incapable of participating in the court process and assisting in an attorney for the purpose, prong two, of developing a defense. So at this time, Ms. Harmon is found incompetent to stand trial.
No deal.
And
No deal. Miss Honorable Webster, I apologize, but we're not doing this today. We're not going to do this today. I wanted to plead out today. And once again, Honorable Judge Webster, I duly apologize for interrupting because I don't want to disrespect you ever. But if I need to fire Mr. Patterson, then I can do that today. But we're not going to.
I don't want to disrespect you, but I do want to disrespect Mr. Patterson. Darren Patterson has the most thankless job in the United States of America. I'm sure he has a couple of clients who occasionally appreciate him and people on Law Talk with Mike who sympathize with him. Other than that, it's just pure hell.
We're going to settle this today. I'm of sound mind and full good faith today. And so either settle this or fire Patterson, whatever we need to do to just get this over with. But we're done here today.
Well,
yes, I'm confident Darren's the problem. I've seen him handle 1,000 cases and he's reasonable every time. But I'm sure he's the problem.
well, Ms. Harmon, this isn't just a concern for your attorney, Mr.
Thank you.
Patterson.
Have a good day.
Thank you. The court will approve, noting that Ms. Harmon has just walked out of the proceedings and the jailer brought her back. Ms. Harmon, as I was saying, this is not just an issue of Mr. Patterson's concern, but of the court's as well. And based on the court's observations and the findings in the competency evaluation, I am finding that you are incompetent to stand trial at this time. And I am going to approve an order for competency restorative treatment to help restore your competency.
Then we can do that at ComCare.
Well, I'm going to order that you shall be referred to and ordered to inpatient treatment at the Larned State Correctional Facility, which is what the statute provides. And that is for the purpose of restoring your treatment.
Hey, good day.
Now wait, and within 90 days after the commencement of your treatment, the hospital is ordered to provide a report of whether you have substantially and probably attained competency to stand trial in the foreseeable future. So the defendant is ordered by the Butler County, the Butler County Sheriff is ordered to transport the defendant to Larned State Correctional Facility as soon as a bed is available.
And Judge,
Anything further, Mr. Patterson?
I have provided that proposed order to Mr. Regier. I just want to find out if I can add his e-signature, submit it to the court today so we can get her on the list immediately to get sent to Larned.
Yes. Mr.
Your Honor.
Mr. Regier?
Your Honor, if the court is ordering that the defendant is incompetent to stand trial and shall be transferred to Larned State Hospital, and the report shall be provided by Larned State Hospital within 90 days, the state would be requesting language in the proposed order that proceedings herein shall be suspended as provided for in KSA 22-3302 subsections A and D.
And the court has so found and ordered and will add any necessary additional language.
Thank you, Your Honor.
So, Mr. Regier, I'm not sure if you, Mr. Patterson, I think he said if you add that language, he'll approve it.
I will do so and then get it submitted, Judge. Thank you.
All right, thank you. Nothing further. We're in recess.
Thank you, Your Honor.
Thank you, Deputy. And do you have anyone else in detention?
No, I do not.
All right, thank you, Officer.
Holy wow. That's messed up.
Osaki, I know that you know this process, but we do have to go through it each time under the People versus Anderson Michigan Supreme Court case. You understand that you've asked to represent yourself. You understand that if you made a request to have a court-appointed attorney assist you, I would appoint an attorney to assist you. You understand?
I understand.
And you still want to represent yourself?
Correct.
Do you have any questions about any of that?
I don't think so.
If you think of any questions during the proceeding today, make sure and get my attention so that I can answer them. Ask for one and I'll provide one for your assistance.
I would like to say something about, I got a 7-day notice about a decision. It was your record for law.
I don't know what 7-day decision you're referencing, so what one are you referencing?
Well, I had a hearing on March 5th, and I got a notice, and it said that you made a decision on January 29th.
So what happens, and perhaps this will answer the question, and perhaps it won't, but whenever we have hearings, I require a party to file an order. And when the parties don't consent to an order, so if you both consented to it, I could sign it, then it's submitted under what's called a 7-day rule. And I sign 7-day orders all of the time, because what happens is if the prosecutor, for example, submitted an order, you have 7 days to object to that order. If you objected to it in a timely manner, then we'd have a hearing regarding it. But if you don't, the court's presumption is the order was accurate, because otherwise there would have been an objection. So was there a 7-day order? I can just check the court file and see if I can identify the one you're talking about. Are you talking about an order following the hearing?
It was March 10th, and it said it was for the decision on the 29th of January.
All right, and so I'm seeing that order. It looks like I signed it on March 20th. Again, I signed a 7-day order when nobody's objected to it after 7 days after the prosecutor or whatever other party files it. So I signed it. It says that the matter has come before the court having reviewed the files and records herein, having heard the arguments of counsel and being fully advised in the premises hereby orders that the defendant's motion to dismiss dated January 29th, 2025 is denied for the reasons stated on.
Well, that's not true, though.
Well, what's not true about it?
It wasn't denied on the 29th of January.
Well, whatever.
It was denied on the March 5th.
Whatever day it was denied, it was denied. The order says that your motion that was dated.
So it doesn't have to be accurate then?
It's accurate. Your motion was dated January 29th. I denied it in the March hearing.
Oh, okay. I see what you're saying. Yes, I understand.
Motion was dated January 29th.
I completely understand.
Okay. So it is accurate. Yes.
Okay.
Oh my God, the stupidest argument possible.
Yes.
If you say so.
You filed the motion. You're the one challenging it, Mr.
But I didn't file the motion on the 29th.
Well, here's the way I view it. You're the one complaining that there's an error and that established to me that there's an error. So I'm not going to take any further action on that issue, but I do want to move on to the next issue, which is the motion to adjourn trial. Did you get a chance to see the prosecutor's motion?
Okay.
Did you get a chance to see the prosecutor's motion?
The motion for June 12th?
The motion to adjourn the trial, the one that we're here for today.
I'm not sure of that. No, I don't think I did.
Mr. Ziegler, do you have a copy of your motion to adjourn trial that you can hand to Mr. Lasecki?
Sure.
I'm looking at the court file and the proof of service. This motion to adjourn trial was filed with the Kalkaska County Clerk on March 28th. The proof of service, hand signed by apparently Mr. Ziegler, indicates that there was a copy provided to you at U.S. mail. So take a moment to review that motion and tell me if you've had a chance to see it yet. It's the same motion that the prosecutor brought up orally at the conclusion of our last hearing, and I told you you had the right to object to it and file a written response if you wanted, or I'd address it whenever the matter came up again before.
I've never seen this motion.
What's your mailing address?
7038 Northwest Gillett Road.
And is that the address that you have, Mr. Ziegler?
That's the address we would mail to, Your Honor. Yes. May have other filings there before in the past.
Right. So, Mr. Lasecki, did you have a response to the prosecutor's motion to adjourn the trial?
You know, my response to that is, you know, this has been going on for like a year, and I would like to get it done.
So would I. So would I. But one of the ways that we need to have it done is we need to have all of the necessary witnesses present. And so I'm going to go through it this way, and I'll let you have the last word. Mr. Ziegler, if you had argument, I'd allow it. I think I clearly easily understand your motion and why you're filing it. But did you have additional oral argument wanted to offer in support of your motion?
Your Honor, just to the terms of the delay, I know this case has been proceeding for some time, but most of that delay was not at the people's request. In fact, we had a trial set, I want to say it was maybe in January, and it was adjourned at the defense request so he could file some motions. He's filed those motions. They've been denied. The requested adjournment is only for 30 days time. Your clerk provided me a date of June 12th, which Mr. Lasecki seemed to be aware of. So for that reason, Your Honor, I don't think it's a meaningful burden one way or the other to adjourn trial for 30 days to ensure that the officer can attend his training and is available for trial.
Did you have further argument you want me to consider, Mr. Lasecki?
That is not accurate. It's been for trial in November. It's been changed to February. It's been changed, multiple times.
Mr. Lasecki, the court needs to make a finding of good cause to adjourn any trial. And in this case, the purported or claimed good cause by the people is that trial was set. He was made aware of the date. He brought up to you the fact that he had an officer that was set for a training on that date. And that training is for basic firearms instruction, where the Kalkaska County Sheriff's Department has arranged for payment for that, and it costs the county $300 for this officer to attend the training. If I continue the trial on May 12th, that would prevent Officer McCormick, from receiving the training, which would generally have a negative impact on the Kalkaska County Sheriff's Department as well as in Kalkaska County in total. And the request is simply to adjourn for a month so that he can both attend the training and that we can have the trial. That does not appear to be an unreasonable request. It's also not unreasonable for you to want to have trial, but it is accurate background that we've had this trial set multiple times at least, and at least on one of those occasions you requested an adjournment because you wanted another opportunity to file a motion, which I let you do. It wasn't unreasonable for you to ask for an adjournment for that purpose. It's not unreasonable for the prosecutor to make a request to adjourn trial here. And more specifically, you haven't told me that there's any prejudice to you. I understand what you would probably say if I let you speak again, is that the prejudice comes just simply in the delay. You want to have this matter off of your chest and out of your mind, and I get that. I also want to get this matter resolved. But the way that I can do that best in using my time is to make sure that everyone that's necessary for trial is there. Here's the downside, is if I found some compelling argument by you, that compelling, and I decided to keep trial on, the prosecutor could, if he decided to, simply dismiss the charges and refile later. That would be a way that has nothing to do with this court's exercise of discretion, which would serve to delay your case further. So what I'm bringing up to you is that probably what you're not seeing is that even if I denied the prosecutor's request, there are potential other ways that the prosecutor could still adjourn the trial without asking me for permission to do so. I don't think that makes much sense, and I'm not suggesting I think Mr. Ziegler would necessarily do that, but it's something that would definitely affect you. It would create more prejudice because it would create more delay. So I don't find that there's any prejudice to the delay. The delay is relatively short. Trial.
I have never adjourned.
Well, I'm not really going to have a back and forth argument with you, Mr. Lasecki.
I'm not arguing.
Well, that's exactly what you're doing. When you disagree in a defiant manner in
Not
the courtroom
arguing.
with something that I said, that's the definition of an argument.
True.
So we're going to
We're back to the argument clinic again.
disagree, and we'll be fine with that, both of us. The order is that I'm going to grant the prosecutor's motion to adjourn trial.
Your light's still red, just so you know. Too.
The red is good. The red means we're recording.
Okay, I heard green.
The red is good.
Okay, thank you.
So we're going to have the new trial date set. And I think in your proposed order, Mr. Ziegler, you had already had that new date, did you not?
I did, Your Honor.
And so I want to make sure
It's in the order.
it is in the order part. And so I'm just going to simply sign this order. Do you want me to use the separate copy, not the one that's already in the court file? There's a proposed order in the court file.
Yeah, there's a separate copy.
I think I have a separate copy of the order.
Can you tell me the date that I adjourned?
No, I'm not going to go through any more of the dates. They are what they are, and
Thanks for your help.
you have the ability, Mr. Lasecki. This is not a complicated process. You've been in court during all of the proceedings, and every decision I've made, you've been looking right at me when I made them. So to the extent that the dates were not January 29th or not March 5th, the dates are irrelevant.
Well, they were
The purpose of the dates is that we were all together talking about the case. We're not going to consider covering what I view to be old ground. And this is a situation where, Mr. Lasecki, again, as I told you most times, because I have to make the finding, I've generally found you to be communicative and cooperative and not difficult. That's the reason why you're still representing yourself in part. Part of it is because you've asked for that. But that right to represent yourself is also limited to the extent the court finds that you're being problematic or making it difficult for me to do what I view as fairly simple things. I'm not in a position to or want to make a change on how you're representing yourself. But if, for example, during your trial, you are so difficult that I have to rehash old things and I have to have conversations over and over again, it may make me decide in my discretion that you're not able to do the role of representing yourself sufficiently, and that you're going to cause difficulties for the court. And I'm just reminding you that if you make me make that decision, that allows the court to then force counsel upon you. I'm not telling you I want to do that. I'm telling you I don't. I want you to be able to represent yourself. But if I have to get in back and forth verbal spars with you, especially if it's in the presence of a jury, it is not going to be to your benefit. I don't allow that to happen from attorneys. I'm not going to allow it to happen from litigants, including you, even if you're representing yourself. So I'm putting you on notice. If you make me do that, particularly in the presence of a jury at a jury trial, it's going to have negative consequences to you in that you're not going to continue to be able to represent yourself. Do you have any questions about what I've said or anything I can further explain for your benefit? Is that a no? Mr. Lasecki, this is the type of behavior that's going to land you in proverbial hot water.
What do you mean? What am I doing?
You know exactly what you're doing, but I'll explain it to you very clearly and cleanly on the record so that you know further. When I ask a question of a prosecutor or a defense attorney or a witness, the required response in a courtroom is a verbal response. And it's verbal for the benefit of you, the benefit of the prosecutor, and my benefit. It records everything. That's why these lights are on. We record every part of a court proceeding so that everyone, including the Court of Appeals or the Michigan Supreme Court, has access to it later. Therefore, if I ask you a question and you don't verbally respond, it's going to, as you can see how it's affecting me right now, it's going to make me upset because it's a clear and easy process. Verbal responses are able to be transcribed.
Sir, I don't want you to get upset.
I don't want me to get upset either. And it's not a particularly difficult conversation we're having, except the way that we have to have it. Do you have any other questions that I can answer for you so that you can understand why I get upset over simple procedural issues?
No, sir.
Mr. Ziegler, do you have anything further you think the court should cover today in advance of our impending trial date?
No, Your Honor.
Mr. Lasecki, I'm going to see you at the morning of trial. That trial date has now changed, of course, but the requirement is, again, that you're here, present, ready to go no later than 8:30. Do you have any questions? Most times I've broken after these hearings by offering you the ability to question the court about general procedural matters at trial. Do you have any general questions about procedural matters at trial, what happens when it happens, or so forth?
I do not.
All right, we will see you at your trial date then. Do you need to get a copy of that trial date now, or can we mail it to you?
I should probably get it now because I didn't get a copy of this, but I did get a copy of the notice of judgment.
Can you get a copy of that order for Mr. Lasecki right now? Sure. So Mr. Lasecki, just stick around for a little bit.
Okay.
We'll have the clerk provide a copy, but I just signed it today. It has a new trial date on it. Again, 8:30 in the morning is a requirement for you and the prosecutor to be here.
And I should be here a half hour early.
Right, a half hour before the start of trial, which is 9 o'clock, so no later than 8:30 in the morning.
Okay.
Yes, sir. All right, thank you. The court is in recess on this case.
This is the state. You jacking me around and railroading me through the trial.
All right. I'm gonna try this. Iris, this is Iris's fault. She tells me that some knucklehead came in to drop some stupid on Judge Middleton. That's always fun.
All right, well, that'll work out. John William Kapp. Good morning, sir.
Good morning.
This is file number 25632ST and 633OT. I don't know how half of this got written under state law and half under ordinance. Mr. George is here. He has authority over the ordinance. But Mr. Kapp, they charged you with a ticket with driving with a suspended license, second offense, which is, that's why, because they can't charge that under ordinance. That has to be charged under state statute because it's punishable by up to a year in jail, fine of up to $1,000, and 2 points on your driving record and a further suspension. This was 11:49 in the morning, and you allegedly had open intox. Wrote ops open container in vehicle. That's why it was split.
Drinking and driving at noon.
Punishable by up to a year in jail and a fine of up to $1,000. You've had a lot going on here in the last year or two. Do you wish to plead not guilty to this and you have a lawyer to help you with this?
I'd like to plead not guilty and change of venue.
Change of venue for what?
For the reasons that I have the option.
No, you don't. You get charged with the jurisdiction where it happened. You don't say, I want to change venue and move this to Pawpaw or Allegan or somewhere.
Well, I mean, my attorney has been a judge and my judge has been, my prosecutor's been my attorney, and
yeah, there is
numerous times over and over, and I feel like it's.
Well, here's an idea. Why don't you quit getting arrested for stuff, and then you wouldn't have to deal with that.
I understand, Your Honor.
But no, you don't get a change of venue. Do you want me to appoint a lawyer for you or no?
Yeah.
Okay, then you can discuss it with them. And if you feel that we should be even if you wanted to disqualify me, they wouldn't change the venue. They'd just get another judge to come here.
Okay.
But you've been paying on your other stuff.
Okay.
Well, you haven't paid since January. That's on the zoning stuff, but aren't you tired of this? I am.
Yes, Your Honor.
Plus you live in Three Rivers. Every time you drive, they're gonna pull you over. I don't know what you got to open intox at 11 o'clock in the morning for. I suspect it was something that was just in there.
Oh, that's kind.
But yeah, well, you got a lot of stuff that you go on. MDOP, you were making payments. You haven't made a payment since last November. I didn't get my cheat sheet this morning. You owe several different things that maybe we'll have to deal with. Anyway, I don't know anything about this, Mr. Kapp, other than what's on the ticket, which ain't much, when and where. But you can discuss the recusal of the judges or whatever motion you have. Oh, here it is.
There it is.
On my face. You have $3,430 worth of unpaid fines and costs. Most of which, is restitution in that larceny case.
7 years.
There's 2724 on that. You have a previous driving suspended from 2024 where there's $475 owed, and malicious destruction of property where you owe 175. And then an old zoning violation, which is down to $56. Anyway, like I said, I thought you'd be tired of this. Anyway, 4/22/25. Defendant plead not guilty. Appoint an attorney. Set attorney pretrial for May 30th. At 8:30. You don't have anything in circuit court. That's all taken care of?
I don't know exactly where I'm at. I gotta talk to the guy.
Do you have a case pending up there? Or are you on probation?
No.
You're not on probation. Do you have a case pending up there?
I've been trying to take care of, yeah.
All right.
So yes.
Well, Mr. Cap, you certainly could use, I know that sometimes you and your attorneys don't always get along, but you need some legal advice here. If you don't like the court appointed one, I guess you can hire one, but you could end up going to jail for this. You keep getting these tickets and you're not paying the tickets that you have. And so it would be beneficial for you to have an attorney. So we'll get you one, see what we want to do. If you want to file any of those motions, you can discuss that with your lawyer. All right, you're good to go.
This one's Zach's
Court is on the
fault.
record, the City of Conneaut versus O.B. Biggs. Case number 25 CRB 28. On April 16, 2025, Mr. Biggs pled not guilty to charges of domestic violence, a first-degree misdemeanor, and unlawful restraint, a third-degree misdemeanor, involving an alleged incident that occurred on January 19, 2025. Prior to his arrest and arraignment, a warrant was issued for Mr. Biggs' arrest because of his whereabouts being unknown. I did set bond on April 16th. Mr. Biggs has not been able to post bond, and so
I think who he's talking to is on the Zoom, because I got this right before I started streaming, so I didn't get to see much. But it seems that he's addressing the Zoom. And another shout out to Law Nerds Unite for all your law nerding needs.
he is appearing at this first pretrial conference by way of video from the Conneaut City Jail. His attorney, Philip Peasley, is in the courtroom. He's appearing at table 2 on the video. Also in the courtroom is Law Director John Lewis, who is appearing at table 1 on the video. Court is in receipt of a pretrial report. Mr. Lewis.
Thank you, Your Honor. The offer that's been extended to Mr. Biggs would be to plead as charged, and the parties would then argue sentence. For the record, Your Honor, the alleged victim, Heather Smith, is not present here today. My office has not been able to contact her, and I don't believe the court has been able to serve her with a subpoena that was issued as well. She is, to my knowledge, homeless. At the time of this offense, Mr. Biggs and the alleged victim were residing together in a tent. So she is not here, Your Honor. I have no input from her as far as what she'd like to see happen, or whether or not what she would like to see happen with the case. Therefore, the offer was to plead as charged until such time as I can speak to her.
Okay.
Thank you.
Thank you. Mr. Easley?
That is correct, Your Honor. I have spoken to Mr. Biggs about this incident back in January and about his current situation, including before today. And we are prepared to accept the offer, which is plead as charged and argue sentence. Mr. Biggs, I think, has been very forthright with me about his need for treatment, Your Honor. And we would hope that the matter would he's aware of his rights to trial. Thank you.
Okay, Mr. Biggs, it's my understanding today, even though there's no alleged victim present, that you wish to change your original not guilty pleas and plead guilty to these charges of domestic violence and unlawful restraint. Is that what you wish to do today?
Can you say that one more time, brother? I'm sorry, I can't hardly hear you on this computer.
Officers, the volume turned all the way up.
Yeah, it's off. Okay.
Okay. Okay, Mr. Biggs, it's my understanding today, even though there's no witness present or alleged victim present, that you wish to change your original not guilty pleas and plead guilty to these charges of domestic violence and unlawful restraint. Is that what you wish to do today?
To be honest, sir, that sounds like that's just saying that I did something that I honestly didn't. I was blacked out, drugged out. So when I was talking with him, he was saying that they was going to help me get with treatment and get on probation.
Well, I think in order for that to happen, Mr. Biggs, there'd have to be some resolution with this case.
He thought it was correct, but it was glue, Judge.
Which your attorney has just indicated to me that you wish to plead guilty to these charges. So, Mr. Biggs, look. Don't act like... Look, I said this to you at the last hearing. Don't act like this is your first rodeo. Okay? You've been in the system. Been through the system. Maybe not in this state, but plenty of time in Tennessee. Okay? So I'm going to ask you again. And I want you to listen to me and I want you to answer me because you've spent a lot of time with your attorney this morning. Now, even though there's no alleged witness here, alleged victim present today, it's my understanding that you wish to change your not guilty pleas to these charges of domestic violence and unlawful restraint, and you wish to plead guilty to these charges today.
No,
Is that what you wish to do?
No, sir.
You do not wish to do that. Correct?
It seems like you're saying that I was forced her to stay there and everything else. I didn't tell her to do anything, sir. No, sir.
Mr. Biggs, pleading guilty is a complete admit. Do you need more time with your client? I mean, because it's like he doesn't understand. Pleading guilty is a complete admission by you to the charges filed against you.
Oh, no, sir.
So you do not wish to plead guilty?
No, sir.
Okay.
I guarantee his attorney explained that to him clearly.
I understand that I was...
Be quiet. Be quiet. I'm not addressing you. Be quiet. I don't want you to say anything anymore that might incriminate yourself. Okay, this case set for pretrial conference. I'll go ahead and set this case for another second pretrial conference. Okay, I set bond in the amount of $25,000, cash surety 10%, with conditions the defendant have no contact with Heather Smith and that he remain drug and alcohol free. I set the bond in a fashion, one, because his whereabouts were unknown at the time of the charges being filed, and so a warrant had to be issued. And then, based on his substantial criminal history out of Tennessee, I have no idea what he's doing in Conneaut, Ohio. And I'm not asking you to say anything, Mr. Biggs. I'm putting something on the record, so don't say anything. He's got a substantial history in Tennessee, which includes failures to appear, warrants being issued, and the like. So he doesn't have a very good history of showing up for court when he's supposed to show up. So, Mr. Heasley, would you like to be heard on bond?
Yes, sir, and thank you. Mr. Biggs did indicate said to me that his mother has serious health issues. He does have 2 construction jobs waiting in the area, and where does his mother live? Where does your mother live, Mr. Biggs?
She's in Andover at the nursing home, sir.
Andover, Ohio, Your Honor.
She's in very bad health, and I'm sorry.
Okay. He's been very forthright from the beginning with me about his need for treatment, and we would hope that, and I do not believe, Your Honor, that he's been assessed for substance abuse anytime in the recent past, perhaps years ago. We would hope that he would be able to get assessed for substance abuse issues to determine what his problem is and what the best course of treatment would be, Your Honor. And if the court is not inclined to release him, which I don't think the court is, hopefully that can be done while he is incarcerated prior to the next pre-trial in the case. Thank you very much. Thank you. Mr. Lewis, any position on bond?
Your Honor, I agree with the court's position. When it previously set the bond, there is a substantial history of failing to appear. And as the court stated earlier, I don't really know what his ties are to Kanye. I don't know if he even has any. And he is homeless, to my knowledge. And for those reasons, the city would ask that the bond not be modified. Thank you.
We have a that we're able to stand on Poplar Street.
Mr. I'm not talking to you.
No, sir.
Okay, but I am going to ask you a question or two. So just listen to my question and answer my question. Why are you in Conneaut, Ohio?
I was with my girlfriend Heather, and it was close to my mother, where I can go and see.
Your mother's in Andover.
I understand that, sir.
Okay,
yes, sir.
so why are you in Conneaut, Ohio?
Because I was with my girlfriend Heather.
So your girlfriend Heather lives in Conneaut, Ohio?
Yes, sir.
Okay. That's your only tie to Conneaut, Ohio?
Yes, sir.
You've been in Tennessee for a long time. How long were you in Tennessee?
Most of my life. Born and raised.
How did your mom get to Andover, Ohio?
She was with my godmother, Louise Roberts, and she had ended up getting a concussion in her head, which gave her a major stroke. They had to put a tube in her throat and put her in Andover, and she's at the nursing home, and my girlfriend has been helping me go back and forth and see her and everything else.
Okay, so even though you were born and raised in Tennessee, your mom was in Andover, Ohio?
No, sir. She was in Ashtabula, Ohio. Just when she had her accident and she had got into the stroke, they had moved her to Andover, Ohio.
Okay. So even though you were born and raised in Tennessee, your mom lived in Ashtabula, Ohio.
No, sir. She was born there as well. She had went to there to visit with my godmother Louise, and she was staying with her.
Okay.
She had went to there. It's too fun.
What are your intentions, Mr. Lewis, going forward? I mean, are you still going to try to locate Ms. Smith?
I would give it one more shot, Your Honor, to try to track down Ms. Smith.
We lost it. There we go. Okay. Go ahead.
Also, the other tie that I have with Conneaut is the jobs that are here. I'm sorry. Yes, sir.
So I'm trying to connect. Frankly, it's just coming to mind to me, and I haven't checked on my own whether Ms. Smith, whether I have a warrant. We have a warrant out for her arrest. Something tells me that she has criminal history in this court, and check something real quick. Having a hard time getting access to our public access.
I'm sure he uses that.
Bear with me.
You was there that one day when she even told you that she wanted the charges dropped, didn't you? What, didn't you come to the house where we were sitting there at the tent?
Mr. Biggs, shut up! Shut up! Just bear with us. Sit there. What is going on with this system? Yeah, I was thinking that I'm thinking that I have a warrant. We have a warrant out. I can't verify that right at this minute. So, I'm going to set this for a second pretrial, but I'm going to say in the next 7 or 14 days, bond will continue as previously set. Okay, anything further, Mr. Lewis?
No, Your Honor, thank you.
Mr. Heasley?
No, Your Honor.
Okay, thank you. This matter is concluded. Thank you. Thank you, officer.
Yep, no problem.
So,
And excuse me if I'm a Matlock fan.
Well, there you have it. That was a lot of fun. Thanks again to Law Nerds Unite, Iris, and Alyssa. I had a shorter stream, but sometimes that happens. I get fun stuff either right before or while it's going on, and then I just roll with it. That was fun in Judge Middleton's courtroom too. I want to change a venue, dude. You got popped there. That's the proper venue. That's how it is. There. Oh, good times. All right. Thank y'all for coming out. I will see you all soon.